Thank you everyone for coming to this 3PB private client update. 2 points of housekeeping before I introduce myself and Ashley to you. There will be PowerPoints used throughout the talk, both by Ashley and I, and they will be sent around after the session, as well as a few articles on some of the cases that we'll be discussing. There is going to be an opportunity for questions and answers, as is always the case nowadays with these things. If you can pop any questions that you have into the Q&A box, and we'll address those at the end of the talk. We've had a couple come through already, one of which we're going to deal with within one of the talks. The other we'll deal with at the end. In terms of the speakers, this morning you've got me. My name's Matthew Wyard. I'm a barrister at 3PB, and I specialise in all manner of court of protection, disputes and advisory work, but with a focus on, nowadays, very much on property and affairs. And then you'll also see on your screen my colleague Ashley Blood-Halvorsen. Ashley is also a barrister at 3PB. She specialises in advisory and litigation work in the fields of contentious probate and property. And she is, fingers crossed, going to be a full STEP member, TEP certified by the end of the year. So good luck with that, Ashley. I know it's not no mean feat to get there. In terms of the agenda today, I'm going to start by talking about the COP and giving you really what is 4 months worth of a case law update. We'll go through 4 cases at some speed. As I say, there'll be comprehensive documents coming around after the talk, so you can consider it all in your own time as well. I'll then hand over to Ashley, who's going to give a wills and probate update, and then we'll deal with the Q&A at the end. Now, that being said, I've got a couple of screens in front of me and I'm going to be referring to both of them. So I'm going to turn my camera off for my talk. I'll be putting it back on for the Q&A. So, as I say, 4 cases we're going to deal with. The first one, which for any of the COP lawyers watching this is probably the one you want to hear about, is the case of Irwin Mitchell Trust Corporation and PW. We'll also deal with a slightly older case, TA in the Public Guardian. We'll look at PSG Trust Corporation and CK. And then very briefly, by way of an honorary mention, I'm going to deal with a recent statutory will application called REP. And I'll explain to you what that's all about. With all of the cases, I'm going to focus on predominantly the practical takeaways from these cases. So lots of them are quite fact heavy, but actually the principles that emerge from all of these cases are arguably quite straightforward and not so fact dependent. So we'll focus, as I say, on practical implications, starting with REPW. This is a long-awaited case. It's still ongoing, but there has been an interlocutory decision recently. In this case, PW is P, who, following clinical negligence, became incapacious. Following clinical negligence proceedings, the case settled and P received a settlement of £1.85 million alongside periodical payments that, it's recorded in the judgment, rise up to £151,000 a year by 2037. As is often the case with large clinical negligence settlements, a deputy was appointed. In this case, it was Irwin Mitchell Trust Corporation appointed an asset management firm to deal with the investments of some of P's settlement. In this case, the asset management firm appointed was Irwin Mitchell Asset Management. And in the judgment, it's recorded that that was appointed following what COP lawyers will know following the REACC decision as a beauty parade method. And we'll come back in more detail to what that is shortly. An application was made for a statutory will by IMTC, and during that application, the official solicitor raised concerns about the asset management limb of Irwin Mitchell being appointed as P's asset managers. And that issue progressed to court, and the issue before the court in this particular case was whether the rules against conflict of interest breached when a professional deputy appointed a linked asset management firm to manage P's assets. The decision is fairly lengthy. like 30 pages. It makes for an interesting read, but if you don't want to read the whole thing, the short answer is the court found, and I've put the quote on the screen, a very clear, not remotely fanciful, actual conflict of interest. And it determined that Irwin Mitchell's process of appointment, i.e. the beauty parade method, was not capable of extinguishing the conflict of interest. The court's rationale ultimately fell to one key point. And you'll see in the judgment, the first paragraph is actually a diagram of Irwin Mitchell's corporate structure that's publicly available information. In effect, Irwin Mitchell, the ultimate holding company, was financially better off if Irwin Mitchell Asset Management was appointed to manage P's assets. And the ultimate point, the beauty parade process that was followed, did not remove the financial gain to Irwin Mitchell, despite the fact, and the court didn't suggest otherwise, that that beauty parade method ensured that the best professional was appointed. And just to remind listeners what the beauty parade method is, it's come off the back of EWCA, where you want to appoint lawyers, effectively, litigation lawyers, to litigate on P's behalf. EWCA concerned a question of whether you could effectively, the trust corporation could instruct its own linked solicitors firm to bring on the case. And what happens nowadays is, particularly in things like education, the trust corporation will get quotes from 3 or 4 firms to conduct the litigation on P's behalf, and then form a best interests judgment and make a best interest decision on which firm to appoint, largely based off that beauty parade, which anecdotally I've heard is largely based on the costs rather than anything else. And the court, in effect, said that that process, in this case with asset management firms, didn't alleviate the conflict because ultimately the financial gain was still there. That's what the case is about, and that's the decision. As I said, largely this talk is going to focus on the practical. So what is the impact of this case? Well, point number 1, fairly obvious. Don't appoint connected asset managers. If you're working within the trust corporation and you need to appoint an asset management company, you now can't appoint your connected one. You need to go outside of your corporate structure. Something that I'm quite keen to see a consequence in relation to now is what happens with litigation. So I just mentioned the beauty parade approach following EWCA. And my own view is that there's a real risk that at some point that approach in relation to law firms litigating on P's behalf could also be hauled before the court, because I think there are similarities and there is potentially a conflict with that approach being used. But ultimately that remains to be seen. There's not been much made of how you can go about trying to ensure your linked asset management firm can be appointed. And I suspect that's for good reason. The reality is you're going to have an extremely difficult time trying to argue that it's in P's best interests or that there is no conflict of interest. But I suppose, judging on what's said in the judgment, if you can remove the financial gain that arises by appointing a linked asset management firm, that might remove the conflict of interest. Although, as is acknowledged in the judgment, it's not necessarily commercially viable. I question whether trust corporations could try to enter into reciprocal relationships, not necessarily in writing, but informal relationships with other firms or asset management companies to try to cross-refer work. That could be a way to try to ensure that you can still have a commercially viable way of appointing an asset management firm. But again, it's probably only a matter of time until that approach would be hauled before the court. And perhaps we will see in the future trust corporations or solicitors seeking the court's pre-approval if they can show that a linked asset management firm is in P's best interests. But ultimately, the future is unclear on what happens with asset management firms that are linked to trust corporations beyond the prima facie position that you now simply can't appoint them. There is more to come on the PW case. There will be more decisions in the future. Whether this will be touched on remains to be seen. That is a very quick, lightning fast look at PW. As I say, you'll be getting a full comprehensive article on PW alongside the slides after the talk. The next decision that I mentioned we touch on is TA in the Public Guardian. This is one from the back end of 2023, although it was published at the start of this year. Again, facts are not particularly interesting or relevant. The crux of the issue here was the extent of the duties owed by a certificate provider when providing a certificate for the execution of a lasting power of attorney. As those practicing in private client will know, when you complete the form for a lasting power of attorney, you complete all the details of the donor, the donee, and you also have to get a witness to sign the certificate to effectively show a number of things that we'll go over shortly. The issue before the court, as I say, was the duty of those signing the certificate, and the competing positions were whether there was an obligation on the certificate provider to hold the opinion of the matters that they are signing in relation to, or to simply provide a certificate. Now, to fully understand this, you need to have reference to Schedule 1 of the Mental Capacity Act, paragraph 2(1)(e). And that says that when signing a certificate, the certificate provider must satisfy itself of an opinion that the donor of the instrument executing the lasting power of attorney understands the purpose of the instrument and the scope of the authority conferred under it. The certificate provider holds the opinion that there's no fraud or undue influence being used to induce the donor to create an instrument. And thirdly, but in the certificate provider's opinion, there's nothing that would prevent a lasting power of attorney from being created by the instrument that's being executed. And as I say, the two competing positions were one, that effectively the certificate was form over substance. What was required under the Act was simply a certificate. The counter argument was that that simply can't be right. The certificate provider is required to hold an opinion when it completes the certificate. The court considered both of the options and found, I suspect to no one's surprise, that the answer was that the certificate provider must hold the relevant opinion and be able to evidence it in order to provide a valid certificate. And the court noted with some comment that it simply wasn't a matter of form over substance. And really, there were two reasons for that. The first one is a literal interpretation of paragraph 2(1)(e) of Schedule 1 to the Mental Capacity Act, which was that on a literal interpretation, the Act requires a certificate provider to hold the opinion, and therefore a valid certificate must be based on that valid opinion about the matters within the Act. And that if the certificate provider doesn't hold that opinion, then they can't validly execute a valid certificate. The second reason was the purpose of the certificate. And as we all know, the reason for a certificate being provided at the execution of a lasting power of attorney is effectively to act as a safeguard to ensure that the LPA can be validly made. And if it was a case that it was simply form over substance and that the opinion did not need to be validly held by the certificate provider, then that safeguard and the purpose behind it was frustrated. So those are the two key reasons for it. What is then the practical impact of the decision in TA and a public guardian? Well, I think there are four key takeaways. The first one is if you're a solicitor and you or someone in your firm is acting as a certificate provider, then you need to make sure that you prepare during or following your meeting with the client a clear attendance note at the point of preparing the certificate that addresses the three specific matters required in paragraph 2(1)(e) of Schedule 1. The court gave some guidance on this in the decision. It said you can't simply record your view of the three matters because that doesn't allow for any objective analysis as to whether what you're saying is correct. What you need to do as a certificate provider is give more detail. Your note should cover things like the questions that you asked the donor of the lasting power of attorney to assure yourselves of the three relevant issues. You should record the answers given to you by the donor, and then you should record a detailed analysis of how the answers given to the questions that you've asked allowed you as a certificate provider to form an opinion on the specific matters in Schedule 1 of the Act. That is obviously of crucial importance because if there is ever a challenge to the validity of the LPA, one of the first things the public guardian does is seek information from the certificate provider. Similarly, if it's not the public guardian seeking to set it aside, you've got no doubt that private client law firm would do the same. And if you've got a comprehensive attendance note that you can send back, suitably redacted, of course, then that will go some way to alleviating the concerns there. The second practical point is if you're not acting as a certificate provider yourself, but you're advising a potential donor or donee to a power of attorney, you need to be giving clear advice to clients on the requirements around certification, and you need to be clear that it's not the case that they can simply find their best friend or their neighbour to sign the certificate. They need to make sure that the certificate provider follows something of a similar process to the one that you would follow as a solicitor. I suspect if this ever gets to court, the standard of note expected of a solicitor will be considered to be greater than that of a lay certificate provider. But nonetheless, I think the court can expect some analysis to be being provided by the certificate provider. The third point is a slightly scary one, which is that there are probably now many power of attorneys floating around that are invalid, because if the requirements of producing a valid certificate weren't complied with at the time of execution, then in theory, those LPAs are no longer valid. The fourth point is to bear in mind that the public guardian will be aware of that, and I would think that they'd certainly be well advised to add this as a limb to any application that it might make in relation to a power of attorney. So private client firms will be used to representing individuals where the public guardian seeks to intervene in the operation of a lasting power of attorney, potentially where there's an issue around whether P had capacity at the time a power of attorney was executed or whether an attorney is acting in P's best interests. To my mind, there's no reason now why the public guardian shouldn't be adding a third limb to its argument, which is whether the certificate was validly executed. And it seems to me that the evidential burden rests very firmly, really, with the certificate provider to be able to show that they validly executed the certificate. And where that's not done, it's probably a relatively straightforward argument to make that the power of attorney itself isn't valid. So potentially we will see these applications being made more often. That's TA and the public guardian. The third case is PSG Trust Corporation and CK. The issue in this case was how a professional deputy should approach the question of informing P of the value of a civil settlement. And there are, to my mind, 5 key takeaways from this decision. Number one, really, is that this is a standalone point in itself. There is a specific question to be determined, which is whether P lacks capacity to request the value of their funds. And that's the question that a professional deputy needs to address when deciding whether to tell P of the value of their civil settlement that they might have, for instance, off the back, as we saw in PW, of a clinical negligence claim. The court expressed in the terms that you can see on the slide the question that needs to be addressed that I've just explained, and it outlined some of the relevant factors. And they are the nature of the information in question. So that will encompass the value of any civil litigation settlement. And I suppose as well as the circumstances in which it was agreed, the risks and benefits of obtaining the value of the funds, or the knowledge of the value of the funds, and the risks and benefits to P of not obtaining the value of the funds. So that's the framework within which, as a professional deputy, you're going to need to consider this issue when you're deciding whether or not to give P details of their civil litigation settlement, and reach a decision as to whether P has capacity to request the value of their funds. If P has capacity, then obviously P can make that decision for themselves. And if they ask, then you would need to tell them. But if P lacks capacity, then in the usual way, a best interests decision will be required. Helpfully, the court was clear that it didn't expect to have to deal with every single best interests decision arising concerning whether P should be told the value of their funds. And that's because generally the court expressed in the decision that it would likely be a common sense decision. So not particularly helpful for the professional deputy, because I suspect that's something, whether something is common sense or not is relatively vague, but hopefully not. The court addressed the point of whether this decision was in the scope of a Property and Affairs Deputy's authority, and it said that it was. There was some argument, and again, without going into the facts of the case too much, as to whether it would make P vulnerable to be told their value of their settlement. But despite that, the court explained that really it's not a welfare issue. What is actually an issue is the communication of the exact sum of a damages award, and that in itself is intrinsically related to P's property and affairs, although there are welfare considerations. The court explained in the decision that it's fairly frequent that property and affairs decisions can have welfare implications. It's not the case that that changes the intrinsic nature of the decision to be made, which in this case is firmly a property and finance decision. Dealing with point 5 before point 4, P's views will nearly always be required in order to come to this decision, because it may be that P doesn't want to be told about the value of their civil litigation settlement, which may end up falling to be determinative of the issue. The last point that I thought was interesting in the case was that a question arose as to whether or not the situation would be the same if it was a property and affairs attorney seeking to withhold or to give P the value of a civil litigation settlement. In the case of an attorney, the court was clear that that always needed to be considered by the court. And the rationale for that is that there's a key distinction between an attorney and a deputy. That is, firstly, that a deputy is court appointed. Secondly, they're required to account to the public guardian on an annual basis. And because of that, they are supervised, none of which an attorney is. So what then are the practical implications of PSG? Well, as a deputy, the rather obvious point number 1 is that you now need to think about this as a freestanding capacity issue when you first take on a client with a large settlement. Does your new client want to know the value of that settlement? Is it in their best interests to know? Do they have capacity to request that information? You may need to obtain standalone capacity evidence on that point when the issue arises. It may be, given the guidance given in the decision, that you feel comfortable as the professional deputy of undertaking that capacity assessment yourself. It's probably not too dissimilar in a sense to litigation capacity. It may be something that you consider yourself capable of doing yourself, but if not, then you will need to get standalone capacity evidence. Once you can reach a decision as to whether P has capacity, you're then, step number 2, going to need to make a best interest decision and make a decision as to whether or not you need to go to court for that. And I would suggest that such a decision should be made as early as possible. As I say, hopefully you can make this decision when P first becomes your client. It may be. I mean, I've seen reference to some documentation that suggests you could consider making the application alongside the actual settlement approval in the first place. But whether that's practical and whether you'd actually have capacity evidence on the point by that time, and whether or not you're in front of the correct judge, probably is indicative of whether you can make it that early or not. The other key point then, if you're not acting as a deputy, but you're acting as a private client advisor, is you need to be giving this advice to your attorneys that you're advising. So if an attorney is acting and P gets a large civil settlement, you need to be explaining to that attorney that if they want to withhold the value of that settlement from P, then in accordance with PSG, they now need to apply to the court for that decision because it's outside the scope of their authority. That's PSG. The last case that gets an honorary mention is Re-P statutory will. And there are two published decisions in relation to this case. One is a substantive decision and one is a costs decision. If you're going to read one or the other, then I would suggest you read the costs decision. It's much more interesting. The point of the substantive decision really is that it serves a helpful reminder that when an application is made to amend a statutory will, all of the beneficiaries, and in this case that included some unidentified charities, must be served with the application to amend. And in the decision, the court went through the previous authorities in relation to when it can forego that notification requirement and reminded the parties that that will only be exercised in exceptional circumstances. That is something that's fairly obvious from Practice Direction 9E. But the costs in the case were interesting. It was a lay deputy who was disputing whether or not all of the beneficiaries needed to be served with the application to amend. And the official solicitor's view was yes, they all needed to be notified. The lay deputy raised some practical issues around the fact that it was an unidentified charity that was one of the beneficiaries, and that made it difficult to identify for obvious reasons and then notify them. But also the fact that P's estate was limited and that the steps taken to notify all the beneficiaries could eat into the value of the estate. The court said that neither of those amounted to exceptional circumstances. And in fact, it went further and said that the lay deputy had fundamentally misunderstood the notice requirements under Practice Direction 9E. What should have happened when the official solicitor notified it of the correct meaning is that an order should have been agreed. And if that had happened, then the hearing wouldn't have been required at all. So for those reasons, the court found that the lay deputy had behaved unreasonably and awarded the official solicitor's costs from the lay deputy. So it is an interesting read, as I say, probably more interesting than the substantive decision, which really reiterates well-known principles. Those are the four cases that we're going to deal with. It's now 11:30. I've been speaking for long enough, so I'm going to hand over to Ashley, who is going to address you on the latest in wills and probate.
Thank you, Matthew. I'm just going to share my screen. Right. We're going to take a look at 4 cases today in theory. I rather suspect I've been overly ambitious with how many cases I want to cover. Now, in my view, the first 2 are probably the most important, but these slides will be sent out afterwards. So if we don't have time, you'll still be able to flick through what I had intended to say about the last 2 slides, well, last 2 cases. Right, let's start with Ria and Ria. I'm sure probably most of you have at least heard of this case, a recent Court of Appeal decision. I'm not going to get into the full background in terms of the procedure, but effectively Rhea has been running for quite a while. It's been ping-ponging around His Majesty's Court and Tribunal Service. Eventually, there was a 4-day retrial before His Honour Judge Hodge KC, which then resulted on a will being deemed invalid. That decision was appealed. So we get the Court of Appeal who reversed that decision of His Honour Judge Hodge KC and granted probate of the 2015 will in solemn form. So what was this all about? Well, the testatrix, Anna, she had 4 children, 3 sons and a daughter. She had made a will in 1986, leaving them everything in 4 equal shares. Now, as she got older, Anna experienced some poor health. And by 2016, she was wheelchair bound. And her daughter Rita was the primary carer around that time. Now, the sons had previously assisted with care, but over the years, it ended up being Rita who became the primary carer. And in 2015, a new will was executed, which left the testatrix property, therefore the majority of the death estate, because most people, it is your family home that comprises the bulk of your estate, to the daughter Rita. The sons were not cut out entirely. They did receive some small legacies. Now, importantly, in this case, the 2015 will, the existence of it was actually kept as a secret. And it had recorded in, I think it was clause 11, that the sons had abandoned her. Now, you could see immediately how that might be inflammatory remarks. The will was drafted and read over by an experienced solicitor, and detailed notes had been taken. And there was a witness who was actually a general practitioner who confirmed capacity and that no undue pressure on the testatrix. Now, starting here, the obvious point to make is the value of a well-documented, notes of a conference with a client for the purposes of taking the instructions cannot be undervalued. A good will file is really important and really key. There's particularly in the case here, you can see that there was a well-experienced solicitor who kept detailed notes and a GP as a witness, and a will challenge was still mounted. So the Court of Appeal has affirmed that probate undue influence connotes coercion. That is different than equitable undue influence, which is on the basis of relationships. And it is easy sometimes to confuse the two, and they are very much different. So when we're dealing with equitable undue influence in terms of relationships, that's, solicitor client, doctor patient, those relationships of power and influence. Now, if you might cast your mind back to about 2017, the Law Commission released a consultation paper into modernizing succession law. And one of the areas that was covered is undue influence. And it highlighted the difficulty in challenging a will under undue influence and the need to protect vulnerable testators from, in particular, financial abuse. And that consultation paper effectively suggested that the two undue influences, probate could learn a bit about the relationships, i.e. Relationships could be absorbed into probate undue influence. Of course, nothing's happened, but that is an interesting point. Now, the importance of evidence is present in every case, and undue influence can be proven without direct evidence. We have that decision of Justice Mann in Schrader. Now, this case, Rhea has reaffirmed Schrader, and this is incredibly important because undue influence, of course, very rarely happens in the open. It's usually in the shadows, in the whispers. Now, what about burden of proof? Well, it is still very much the civil standard, but Here we have a quote from paragraph 27. It is a civil standard, but Lord Justice Newey said that undue influence is inherently improbable. Now, I'm not sure I'm quite as optimistic as Lord Justice Newey in terms of human nature, but this is what the law is as it stands. Okay, now what about the alternative hypotheses? This, in my view, is a very difficult hurdle to get around. So the alternative hypothesis comes from Justice Lewison in the Edwards decision back in 2007. What must be shown is that the facts are inconsistent with any other hypotheses. Now, that requirement, in my view, has proved to be quite problematic. And I have personally advised in some cases that there are potentially other hypotheses, and that has proved a problem when assessing prospects. However, paragraph 32, I would accept that undue influence can be proved without demonstrating that the circumstances are necessarily inconsistent with any other alternative hypotheses. Honestly, thank goodness for that. This for me is a slight breath of fresh air. We have slightly rowed back, but I would not think or suggest that this opens the floodgates for undue influence. Undue influence is still going to be very difficult to make out and get home on. But I think we have taken an ever so slight step backwards, and I think that is sensible, and I applaud that. So back to Rhea and Rio, what were some of the facts? Well, the testatrix at the time was frail. Rita, the daughter, had a forceful personality and a physical presence. Anna was dependent on her daughter. Rita's evidence about the circumstances for the change had been rejected, and I'm pretty sure Rita had been found to be an unsatisfactory witness. The will was shortly drafted after the sons had stopped helping Rita with her care. Rita made the arrangements for Anna to visit the solicitors. The abandonment reference would not have come from the testatrix, but rather Rita. The testatrix had told her GP that the sons had their own properties, but Rita also had a flat. And Rita actually had some motive. She needed to sell her flat to pay for some debts. I'm pretty sure it was benefit overpayments. And then, of course, finally, Rita's failure to disclose the will until her mother had died. Now, direct evidence of coercion is not necessary, but without it, how can you actually prove that it is coercion and not just persuasion? Well, we know fundamentally that these cases are going to be unpredictable, and they're still going to be unpredictable. And this is one there's always good reason to settle. We will tell our clients, we will tell them again. Whether or not they listen is a different matter, but we will tell our clients. And they need to understand that the persuasion is permissible. So, you know, my siblings are well off. They don't need the money. They don't need the money. Mother, I'm the one that takes you to your hospital appointments. I am the one that cares for you. We have a roast every Sunday. Where are my siblings? They're not here. That is all permissible. So it's about finding this line. And that line, where it is largely going to depend on the deceased, where they were in life at the time that the will was executed. So once again, value of a good will file. Ask about previous wills. And be particularly alert if there has been a quick change in wills, or if there's been some significant changes in the dispositions, or where one person is a clear winner. Now, the testator, they always have testamentary freedom, but I think having a somewhat suspicious attitude will probably be of assistance. Moving on now to Leonard and Leonard, a decision of Justice Joanna Smith. Brief background. So this deals with Dr. Jack Leonard. and the children from his first marriage, they brought a claim to pronounce against a will signed in October 2015. Now, the will was prepared by a tax advisor who took the instructions, but then did not meet with the testator for almost a year before it was executed, and the golden rule was not followed. Now, the will was eventually deemed as invalid as he did not have capacity and for want of knowledge and approval. Now, this decision is great. I would save it, bookmark it, add it to your library. It covers testamentary capacity, want of knowledge and approval, expert evidence, and the golden rule. So it's effectively a one-stop shop, I would say. So some key takeaways. The first limb of banks requires a testator to consider the specific will and not the effect of a will in the abstract. So there's actually been no real authority on this point. It's not something I've ever argued personally, but this is a welcome clarification. So it's not about what a will does or the concept of wills. It has to be the will which is being put before the testator. Once again and again, banks, it's not a memory test, only necessary to have a general idea of the assets. Now, I would say that where an asset is of a particular value, specifically monetary value, for example, being a beneficiary of a trust of land, or something which is of significant sentimental value, I would hope that my testator remembers those assets and at least raises them. You don't need a testator to be remembering previous wills or even testamentary promises. In terms of the decision itself, it's paragraphs, I think, 148 to 171 that Mrs. Justice Smith, she weaves in some key cases into a comprehensive summary. Further key takeaways. So the fourth limb, it's not just insane delusions, but it extends to any disorder of the mind which perverts one's instincts and affections, and I've highlighted the paragraphs there. This, I would say, is probably the most modern and forward-looking aspect of this judgment. Now, we've had various medical experts, they've disagreed somewhat on the extent of whether the fourth limb does or should encompass long-lasting illnesses such as dementia specifically, as opposed to short episodes such as delusions. In my view, that this must include dementia, and I would suspect that many people who are participating today have had either family members or close friends who have suffered with dementia. And that will impact a sufferer's empathy, can cause them to be aggressive, irrational, their general personality. So that, I say, must be relevant for the fourth limb. What about mental illnesses generally? We shall see. Cannabis psychosis? Probably. Now, there has been some going back and forth regards to the Mental Capacity Act 2005 and the testamentary capacity test. There was a decision, I'm not sure if you're aware of it, Baker and Houston from His Honor Judge Tyndall. Now, His Honor Judge Tyndall is a judge of the Court of Protection as well as Chancery. And in that decision, he applied the testamentary capacity Banks and Goodfellow test, but then use the statutory test as a cross-check. So an interesting methodology. Now, this case, I'm pretty sure it's not been referenced by any of the recent authorities. So it's sort of been drifting right now, but I wonder if maybe it might be referenced in the future. So the criteria in Banks and Goodfellow, they're not directly questions of medical nature, but for common sense, judicial judgment depending. So once again, that common sense is coming into it. You will have to analyze the entirety of the evidence, as will the judge. And the complexity of the will be important. So if you've got a straightforward 1 or 2 page will, which effectively gives everything to the spouse. That's one thing compared to another one, which is a lot more complex, which has various trusts. Those are two different exercises in terms of analyzing the facts. Parker and Felgate. It does not work if the early instructions are not fully reflected in the executed will, or where the earlier instructions are confused. What about expert evidence? So paragraph 139, I've just plopped out here in this slide. And this paragraph, I think it essentially sets out the boundaries of where a medical expert report ought to cover. The job of a medical expert is to report on the nature and likely cognitive impact of the conditions from which the deceased was suffering from. So that will mean looking at the medical evidence, the health records, and what have you. Now, we actually had one question sent in before today, and I'm going to answer it now because effectively this slide, I think, is key for that. And the question is this: to what extent does recent case law on lack of testamentary capacity show a move away from a retrospective capacity report being determinative and towards the idea that the report is just one piece of the wider evidence? Well, thank you for that question. And the answer, at least in my view, is this. A retrospective capacity report has never been determinative. And I appreciate that there can be a disconnect sometimes in law and what happens in practice, particularly when you're dealing with your clients. And in my view, it's a little bit akin to a boundary dispute. If any of you here do that work, boundary dispute, you get a surveyor on board, goes out to the site, produces a report. All a surveyor does is reports on the topographical features on the land, and where the legal boundary sits is a matter for the judge. It is the same thing in my view here, okay? So a medical expert, they report on the conditions that the deceased had, what cognitive impairment that might have had, but a judge will be looking just beyond that and to all the evidence which it has before it, because this is, at the end of the day, a judicial question to be answered. So it might be a retrospective capacity report is the most important piece of evidence, but it's not determinative. Right, I'm going to very, very quickly whiz through this because I've just seen the time. So Sim and Pimlott. This, too fast. This has to do with non-contest clauses in a will. So the widow of Dr. David Sim, made a Inheritance Act provision for dependents 1975 claim. Complicated marriage. She had actually made numerous criminal allegations against him, and they were in the process of divorcing, but it had not been finalized. He died in, I think it was January 2018, and the will was from 2017. Now, there were various clauses within his will. I have put them on the screen there. It is worth noting that she was also entitled to his pension. Now, non-contest clauses, effectively what they do is they're exactly as they sound. So it would commonly state that a beneficiary would lose their entitlement to an asset or assets underneath a will if they decide to challenge the will. It's effectively to discourage applications to challenge a will or making applications underneath the 1975 Act. Now, in the terms of the 1975 Act, a no contest clause will be deemed to take effect whether or not the challenge succeeds or fails unless the clause itself states otherwise. So you've got to be really careful with these. And this is what the court found. Effectively, you can't pursue a 1975 Act claim with the knowledge then that you're going to forego a benefit and then say because you have foregone that benefit, the will fails to make reasonable financial provision. That must be right. I mean, that's entirely sensible. Where a will is objectively reasonable, and it's also reasonable to include a provision intended to discourage a beneficiary from bringing a claim. So practical points. So this confirms the enforceability and the usefulness of these claims. It's a useful shield. I have seen, and I'm sure you have seen, an absolute increase in Inheritance Act claims. It's booming right now. Will we see an increase in non-contest clauses? I would think so. And I would think in a way, this is also a shift towards testamentary freedom being restored. I feel, at least in a way, it's been eroded a bit over the years. If you act on CFAs, you're going to want to add this to your standardized risk assessment with those. And don't forget a non-contest clause. It must be appropriately pitched. The final case, I'm not going to go through because I want to leave enough time for some questions and anything further. But effectively, this case, really interesting. It deals with when there is a will challenge afoot and who gets to deal with the funeral arrangements. Once again, another area I'm seeing an uptick in business. So take your time when these slides are sent out afterwards and review what I've put there. Now, just very briefly before we actually get to the questions and answers, there should be a feedback form, which I think will go out afterwards. And one of the things I'm looking for feedback is, what would you like to hear about next? What sort of talks would you find useful? I've got two things which I'm thinking about, but I don't know if you would find that interesting. So the first one we've seen, I think it's about 3 or 4 decisions recently in terms of professional personal representatives, their remuneration. It's been a bit of a hot topic, particularly for solicitors. Another one which I've gotten interested in and I'm seeing an uptick in is financial abuse and what I call dodgy attorneys, i.e. somebody who's had an LPA done, they've appointed, usually it's their children or some family member as an attorney, and also the attorney is making loads of gifts, particularly to themselves. So would love to hear your suggestions and your feedback. At this point, I'm going to stop sharing my screen.
Got some validation there in the chat. Ashley, someone has responded straight away and said both of your subjects would be good for a future talk.
Yeah, you never know sort of what your interests are, if it's something that other people would like to see. Right, okay, so in terms of questions, shall we get to that? Both in particular LPA financial abuse, yeah. Yeah.
It's a massive issue at the moment.
Yeah, it's quite sad, I find as well. And a lot of it's come out of effectively the COVID lockdowns. That I think was ripe for these sort of issues to crop up.
So quite one of the questions that's come in is from a local authority. In relation to adult social care, should the deputies, presumably that's a property and affairs deputy, take active part in discharging payments for the provision of care? So I assume what this is getting at is where P lives in a care home, they've got a P&A deputy who pays the fees. I suspect that might be more my cup of tea than yours, Ashley, but obviously jump in if you've got thoughts as well. I would say yes, the deputy should be assisting discharge P's liabilities. They are in control of P's finance. And if P is liable to pay care home fees, then they should be being paid. There's probably a wider issue there. If a deputy, I would assume that deputy in that instance who wasn't paying would be a family member rather than a professional deputy. But if there was an issue around whether or not it's in P's best interests to be living in that particular care home, that is certainly in my experience where I've seen lay deputies say, well, I'm just not paying fees because I don't think they should be there. And if that's the case, then you need to get to the bottom of that issue as well before you start issuing debt recovery claims and things. But yes, in answer to the question directly, should deputies take an active part in discharging payments for provision of care? Generally, yes, subject to that one caveat.
Yes, I would say the same thing in terms of personal representatives. Obviously, by that time, P has died, and it's now debt. Now, a personal representative has to be satisfied of the debt, and it's legitimate. And one problem I have come across when advising effectively PRs is oftentimes care homes, if they're private, they're run, I'm not sure how to say this, but they're not the most efficient of machines or uh, professional in a way, i.e., the invoices can be unsatisfactory. Sometimes they have references to different legal entities. So, uh, as a PR, you need to be satisfied, but take a look at the invoices. What is the legal relationship there before you start paying out? Because then, of course, you've got to answer to the beneficiaries who might not be too happy that money has disappeared. Um, I've got a question as well to answer here. So, with undue influence, experts should confine themselves to the medical evidence, but what about where the medical evidence is unsatisfactory, scant, or incomplete? Okay. So, the court is saying medical experts effectively stay within your area of expertise, but what happens when the history, the file is not comprehensive? Well, I think in that circumstances, then um, a an expert would be probably permitted to comment on non-medical documentation or facts contained within a witness statement. Um, but ultimately, the court is the tribunal of fact, and the court is perfectly entitled to make findings which run contrary to an expert report or undermine an expert's assumptions. So, but I would think, but certainly by the time a testator has reached elderly age, usually there is a good history. But yeah, I would say if the file is lacking, then your expert probably can veer off a little bit, but not too much.
I've had a question put in the Q&A, Ashley, which is where one of two attorneys, so there were two attorneys, one of them is suspected of misappropriating the donor's funds, and they are removed or resign following investigation by the public guardian. Might there be scope for the surviving attorney to seek approval to make a statutory will to effectively recoup the misappropriated funds so that the removed attorney has their share of estate? Would you right? So the question is basically where one attorney is removed,
Mm,
make a statutory will and reduce that attorney's benefit effectively from the will to reflect the funds that have been misappropriated. Um, Lawyer answer, maybe. In terms of executing a statutory will, you need to make sure that the contents of the will is in P's best interests. And that is really the only consideration. So you could potentially do it. You just need to argue that the attorney shouldn't benefit because they've misappropriated the funds. I think you'd have an easier time doing that if there's been a factual finding made by a court, if there's been an application by the public guardian, than if you just suspect that they've done various things with the funds. But yeah, ultimately, maybe is the answer. Ashley, what are your thoughts on that?
yeah, I think you're right on that, in the sense that it is very much a lawyer's answer, and it has to be in P's interest, doesn't it?
Yeah. There's been another one.
Yes, I've seen that.
So what evidence have you seen go against a retrospective capacity report, which has ultimately defeated it?
Hmm,
I think this is really interesting because you have a very different take on retrospective capacity assessments than I do, because you see
yes,
them dealt with in the civil court, I see them dealt with the COP.
yeah,
Um, from the perspective of the COP, retrospective capacity assessments are a pain because they're usually done far too far after the event.
yeah,
Um, Looking back, and half the time when experts are instructed, they're not given the relevant GP evidence, medical evidence, and you can undermine them quite easily. What's much better, in my view, when you look at a retrospective capacity assessment, is to have it done as close to the time as possible. Um,
yes. Yes, in terms of what other evidence, not necessarily what would defeat a retrospective capacity report, but just other evidence in general. Of course, you have other witnesses, and that will, at the end of the day, depends on how the court finds them. That can be risky. In one of the cases I'm dealing with, it was one of these issues during lockdown, an elderly lady, and there were concerns afoot at that time already, even though she was still alive, about the influence of one of the family members. And they actually took some video recordings of the elderly lady. Now that, of course, will have a limit in terms of its usefulness. But in today's day and age, with everyone just about has a smartphone in their pocket, those sort of recordings can actually be very useful. Not everyone thinks to do it, because not everyone is, I think, inherently suspicious. But that, I think, is going to be important in the specific case I'm dealing with. Other evidence could be emails, it could be documentary. It's the usual suspects in my view.
You can get other medical evidence as well. I mean, I had a case, public guardian was applying to remove an attorney, and it was the question of whether or not P had capacity to execute the power of attorney at the time they did. Public guardian got a retrospective capacity assessment report done, which was very good. We, in response for the family, and in response, we, for the attorney, we tried to obtain counter medical evidence from the surgery that was more contemporaneous. We also, although this was ultimately didn't bear any fruit, decided to get evidence from the local priest. So it was a Greek Orthodox family, and they thought that evidence from their Greek Orthodox priest would be an excellent way to try to rebut medical evidence. It wasn't. So you can do. There are various things that you can do, but it's completely case specific, which is the difficulty.
Right. There's one further question and answer which question which has been asked in the Q&A box, and then I suspect we will have to wrap up. Are medical entries where the testator has given medical consent supportive of the testator having testamentary capacity? Well, giving consent for medical issues is very much different towards having testamentary capacity. So also, I don't know what sort of case you're dealing with, but my immediate reaction is maybe, but it doesn't sound like the most persuasive of evidence. It might be something which just adds into the mix, but they are fundamentally different questions, though, I think.
Yeah, I mean they are. Yeah, they're completely. I mean, to have capacity to consent to medical treatment is a its own standalone test that don't even need to get into that today. It's extremely complicated, but
Yeah, yeah.
very different.
All right. Well, I think that's us done, Matthew.
Good. And only 5 minutes over as well. That's good.
Not bad, not bad at all. All right. Well, thank you everyone for attending and for your time. And I hope you have a good afternoon and hopefully see you again soon.
Thanks, everyone.